There are two major branches of law, right? Really, basically, there are torts and there are contracts. Okay? When one agrees to perform under a contract, right, what is one doing? In the language that we want to use to talk today. Mr. Siegel? What's that? When one agrees to perform under a contract, what essentially is one doing? They're assuming a duty to do what they say that they're going to do, right? And so this first chapter here talks about privity of contract, right? And what the preliminary section of the chapter talks about is that formerly, okay, there had to be an agreement between two parties. In other words, two parties had to be in privity. They had to have a relationship, one to the other, in order for any duty to arise, and that duty generally arose out of an agreement between the two based in contract. Okay, and we'll talk about it again in a minute when we get to Winterbottom. But, so, look at the text, first page there. Third restatement, section 7, duty. A, an actor ordinarily has a duty to exercise reasonable care when the actor's conduct creates a risk of physical harm. Okay, when your conduct creates a risk of physical harm, you have a duty to do what? Act as a reasonably prudent person. Thank you. Okay? In exceptional cases, when an articulated countervailing principle or policy warrants denying or limiting liability in a particular class of cases, a court may decide that the defendant has no duty or that the ordinary duty of reasonable care requires modification. Next sentence. Where a person creates through his or her negligence a risk of physical harm, a duty is imposed. A driver of an automobile owes a general duty of care to others whom he reasonably foresees will be injured through his or her driving. Okay? Reasonably foresees will be injured through his or her negligent driving. Okay? The book draws a distinction on the next page between nonfeasance, these are important things, right? Nonfeasance there in the second full paragraph under privity of contract. In general, when there is only the promise and the breach, only the contract action will lie, and no tort action can be maintained. And you'll notice there in that example, some poor guy had to walk back from Cincinnati to Atlanta. Whew, I bet he was tired. Notice the exceptions at the bottom of the page. One exception is that a public utility or common carrier that has undertaken the duty of serving the public becomes liable in tort when it fails to do so, whether or not it has made a contract. So the question is, notice that there's a gray area here between what can be a tort action and a contract action. And that's what the editors are trying to get at here. Misfeasance. Notice when the defendant misperforms the contract, the possibility of recovery in tort is greatly augmented. Okay, so the example here, the simple example here is what? I take my car to the brake joint to have the brakes repaired on the car. So I contract with the brake repair guy to fix my brakes. He negligently fixes the brakes, okay? He does a poor job, and then I have an accident running into a tree. The action that I would file against him is not a breach of contract for failing to do what he said he was going to do, but for breaching the duty that he assumed by failing. He assumed when he attempted to fix brakes and did it poorly, right? That's a tort, not a contract. The other simple example of nonfeasance there is what, Green? Did you lose me? What would nonfeasance be in that example? No, if he told me he was going to fix the brakes and he didn't do anything, that's a breach. That's not a tort. He hasn't misperformed. He has not performed at all. That's nonfeasance as opposed to misfeasance. You get my drift?
Yes.
Okay.
Say that.
If he tells me he's going to fix the brakes, right, and does it, and I contract with him to fix the brakes, we have promise, we have consideration, acceptance, okay, and then he doesn't do anything. He just gives the car back to me, right? Then that's nonfeasance. He breached the contract by not living up to his promise. If he attempts to fix the brakes and doesn't do it right, and then I have a wreck, that's misfeasance. He has undertaken the duty and he has failed in that duty, and therefore that is more likely to sound in tort and not in contract. You good with that? You see that? Good? Ms. Clark? Good?
Yeah, can both the misfeasance and nonfeasance be torts?
No, the point is that nonfeasance is an action in contract. Okay? Except under the limited exceptions listed at the bottom of the page.
So the exemption at the bottom of the page is in the tort? Is that what you're saying?
No, yeah. Notice, one is that a public utility or common carrier that has undertaken the duty, okay, we can just insert our brake repairman in there, of serving the public becomes liable in tort when it fails to do so, whether or not it has made a contract. Okay, notice the difference is liable and tort. And we're going to, when we get to McPherson and Judge Cardozo again, he's going to talk to us about that. Okay.
Question. So in that exception, it's always going to be a tort action when it comes to our public utility and common carrier, as opposed to a contract action.
Yeah, why would that be, Vicki?
Because you don't make individual contracts.
There you go. Ding, 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 ding. We got a winner. Because there aren't individual contracts with the public utility. It's made for the public good. Therefore, it sounds in tort, not in contract, because there is no privity. Okay? Now, further down on 425, when the courts have been presented with these sorts of gray area causes of action, right, there have been two general solutions to the problem. One is that plaintiff files the case. One is election, right? Plaintiff files the case and pleads both an action in tort and an action in contract. The court then will say, hey, well, okay, here's the deal. You know, let's make a choice. You got to make a choice, right? You got to choose. You have to elect to sue under the contract or under the tort. Now, the book makes, you know, what's the? I mean, it's kind of, well, I don't know. It might not be early. Why would one? What might be an advantage to suing in tort and not contract? Go ahead. Go. You might get punitive damages, right? In contract, what's the goal of an action in contract? To make you whole, right? In tort, you might be able to get a little bit more than whole, right? You might be compensated for things that you might not be compensated for in contract. There aren't emotional damages available in a contract action, right? So, under election, right, you have to choose whether you're going to sue in a tort or a contract, or the court will take a look at it and and make a determination as to the gravamen of the complaint, and as the book points out there at the bottom paragraph, what are the essential facts on which the plaintiff's claim rests, right? What is going to be determined? What facts are going to be determinative here? And if they lean more toward tort, or they lean more toward contract, the court will make the decision for the litigant.
Contract.
Okay? So, Winterbottom. Mr. Stokes.
Sir.
Winterbottom.
Winterbottom was a manufacturer of male coaches.
See, as long as y'all speak up, we're going to do away with the standing up because it's 3:30 and y'all have been here all day. And again, I love you. You're crazy. Go ahead. Loudly.
As part of the contract with the coaches and conditions, personally assuming that all of the coaches were in good repair. The postmaster was to supply the horses and drivers for all the coaches. And Winterbottom was employed by Atkins as a driver. One day, coach had been serviced by Wright. A lady defect called the coach to break down and threw Winterbottom against the ground. Winterbottom took damages about 2 weeks.
Louder.
For damages.
So what's the deal here? So Winterbottom is employed by who?
Winterbottom's employed by Atkins.
Atkinson, right?
Yeah.
And
Right.
so who is Wright?
Wright was the owner of the coach, who owned all the coaches.
Right, as part of the contract with the postmaster, Wright was supposed to keep the coaches in good repair, right?
Basically,
So Atkinson, wait a minute, Atkinson had a contract separate from Wright with the postmaster
right,
to what?
to keep the coaches up.
No, Wright kept the coaches up. Atkinson was providing the horses and the drivers.
Horses and drivers.
Okay, so Winterbottom worked for Atkinson.
Right.
Okay, and so you see where we're one removed from Wright, right?
Yes.
We've got
Third party.
Third party. And the
third
point is that Winterbottom
Basically, what I got from this, if you got a contract with one person, that another person can't sue on behalf of them being negligent performance if they don't have a contract that person. Did I get that right?
yes.
That's what I got.
Okay? Because there is no line between Wright and Winterbottom. They're not in privity of contract. And because back in the day, right? Back in the day, the only duty owed was between two people under the contract theory. Winterbottom, in this instance, is SOL. Okay? I won't have to tell, I hope I don't have to tell you what SOL is. Okay?
Okay, so I had a question about this.
This is old law. I know what was coming
Yeah,
next.
you know what I'm saying?
All right, this is old law. Reading this case is about understanding how the law developed. Okay?
Notice, 4 lines into the opinion. There is no privity of contract between these parties, and if the plaintiff can sue every passenger or even any person passing along the road who was injured by the upsetting of the coach might bring a similar action. Further down, those, however, the exceptions are cases where the real ground of the liability is the public duty or the commission of the public nuisance
And what's the court worried about here? The court is worried about burdensome liability on a large scale, right? The opening, proverbially, I think we've seen this before, opening the proverbial floodgates of litigation. That if Wright could be held accountable to Winterbottom under these circumstances, then Wright's liability to any third party that happens to come into contact with the coach would be too great. Okay? And again, this is old law. And there's Lord Abinger himself. Look at Alderson, just above the picture. The only safe rule is to confine the right to recover to those who enter into the contract. If we go one step beyond that, there is no reason why we should not go 50. The only real argument in favor of the action is that this is a case of hardship, but that might have been obviated if the plaintiff had made himself a party to the contract. And notice there's a famous quote in the next opinion by Rolfe at the bottom. You know, the court, these judges are sympathizing with Winterbottom because apparently he was really hurt, right? And they're saying that hard cases make bad law, right? They're saying this is a difficult decision because we don't like the fact that we're leaving Winterbottom here without a remedy. But were we to have sympathy and change the law in this instance, then it would be a bad law. That's what it means, like hard cases make bad law. Okay? This is a hard decision to make, but make it nonetheless. We are. Okay. McPherson v. Buick Motor Company. This is another one of those seminal cases. Okay? Because it changes the landscape of the privity of contract issue. So give me the facts. Right side. Mr. Dixon, go.
All right. This was a case where Buick, the defendant, sold an automobile to the retail building. Retail building was sold to the plaintiff, Mr. McPherson. While the plaintiff was in the car, it collapsed. He was thrown from the car and injured. The wheel was made of defective wood, however, it was not made by Buick. Buick bought it from another manufacturer. There is evidence that suggests that defects could have been discovered by reasonable inspection. There was no claim that the defendant was aware of the defects. So the issue is, did Buick breach the duty of care for foreseeable use of the product? Being that it was most likely to cause the injury because it was negligently made and placed the product on the market without an inspection. And so the conclusion was that, yes, Buick was reliable or responsible. Buick was not believed because it bought the wheels from another manufacturer. It still had the duty to ensure that there was a reasonable inspection.
Because without the reasonable inspection, what?
Without reasonable inspection, what now?
Right? Like, where did the duty come from, then?
It came from.
If anybody blurts, you're going to pay. Go ahead, Mr. Dixon.
Because it had the contract with McPherson.
Did he have a contract? Who had a contract with McPherson?
Oh,
Buick?
no, I'm sorry. Buick had a contract with the manufacturer.
Buick is the manufacturer. Had a contract with the manufacturer of what? Who's putting the total product on the market?
Buick.
Buick.
Yes,
and so is
and
okay.
McPherson is the person who bought the actual.
But wait a minute now. So the question is this: Did McPherson buy the car from Buick?
He bought it from retail.
See what I'm at? Right? And moreover, okay, did Buick manufacture the tires, the wheels?
No.
No. So we're somewhere, we got somebody else. So go back to our trusty little dry erase marker over here. We've got Buick, right? And we've got the wheel manufacturer, right? They weren't tires then, they were wooden, right? But we'll call them tires. Then we've got the retailer. Way down here at the bottom, we have our injured plaintiff. In the old days, right, like what we just talked about, does Buick owe it to whom, under the principles enunciated in Winterbottom, let's put it that way, to whom does Buick owe a duty?
Nobody.
Right. It owes a duty to the retailer because that is whom Buick is in privity with, right? And so because McPherson is so far away from Buick under the old days, where the duty arose out of a contract, McPherson doesn't have an action against Buick. This is what Cardozo is about to step all over. Okay? So, notice at the top, at the very top of the page, on 429, above the picture of Judge Cardozo, the man, the legend. The question to be determined is whether the defendant owed a duty of care and vigilance to anyone but the immediate purchaser. Okay? The immediate purchaser being, the dealership, the retailer. Don't get confused there. Okay? Good. We hold that if the nature of a thing is such that it is reasonably certain to place life and limb in peril when negligently made, it is then a thing of danger. Its nature gives warning of the consequences to be expected. If to the element of danger there is added knowledge that the thing will be used by persons other than the purchaser, other than the dealership, and used without new tests, then, irrespective of contract, outside of Winterbottom, okay, the manufacturer of this thing of danger is under a duty to make it carefully. Skip a sentence. There must be knowledge of a danger, not merely possible, but probable. It is possible to use almost anything in a way that will make it dangerous if defective. Notice, skip a sentence. Whether a given thing is dangerous may be sometimes a question for the court and sometimes a question for the jury. There must also be knowledge that in the usual course of events the danger will be shared by others than the buyer. Like Buick knows that when it sells this car to the dealership, that the dealership is going to sell it to somebody else. So they knew it was going to be used by someone other than the immediate purchaser. Further down, we are dealing now with the liability of the manufacturer of the finished product who puts it on the market to be used without inspection by his customers. If he is negligent where danger is to be foreseen, a liability will follow. A duty arises and a liability will follow. We have put aside the notion, here it is, big stuff right here. We have put aside the notion that the duty to safeguard life and limb when the consequences of negligence may be foreseen grows out of contract and nothing else. We have put the source of the duty, the obligation, where it ought to be. We have put its source in the law. We are taking it out of contract and we are putting it into the common law definition of negligence, products liability, whatever you want to call it. Okay, do you see that's a huge transition? It is a huge switch. If you didn't catch it, now you have. Okay? Question?
I was just curious, I was looking at the years of cases. This one.
Oh yeah, Winterbottom's very, very old.
Yeah.
Okay, Mr. Gunter.
So basically what Cardozo is doing in this case, in regards to what was addressed in Winterbottom, is how they say that the passengers and the people on the road can now sue him. Now if there was a wreck caused by this defective car, anybody else injured can now sue you as well for the defective product, correct?
Right. it used to be that we only had a duty between A and B because of the contract between A and B. Okay? Now, now what Cardozo is saying is that the Lord Abinger was unduly afraid, right? Now, as long as it's foreseeable that C is going to be, and go back to what three-word phrase did Judge Cardozo give us in Paul's graph? The zone of danger, zone of apprehension, right? As long as it's foreseeable that C is going to be in the zone of apprehension, the zone of danger, right, by the use of a defective product, then C now has a cause of action based in tort, not in contract, against A, because there was no privity between the third party, who is C, and the initial manufacturer, who is A. Okay?
I think, would it matter what it was? Because it talks in the case about articles inherently dangerous. So does this mean anything that you could?
No, it's saying that it's not. It doesn't have anything could be dangerous if it's used, if it's defective and used in a certain manner. It does not have to be inherently dangerous. But I put to you here: is a car an inherently dangerous thing?
Yeah.
Yes, right. But we're talking to expand upon that. It doesn't have to be inherently dangerous. It can be. It's only if it is dangerous if it is defective. Okay. We're not talking about. We're not going back to the inherently dangerous argument that we had about the golf club left by the parent in the backyard, right? Uh-oh, this is about to be disastrous. Thanks for warning me, guys. Hey, Dean, before you do that, you might want to undo your...
You should have known.
You knew or should have known.
You should have known.
Yeah, you smarty.
Reasonable person.
A year, yeah, right. Right?
Yeah.
A reasonable person. That's true.
A reasonable person would know.
Look at that next paragraph. This is because B is then under the duty to repair it. Oh, wait a minute.
Where are you?
Wait a minute. I'm in the next paragraph, middle paragraph on 430. Oh, all right. All right. Hey, all right. Yes. If A, look, that middle paragraph. If A leases to B, stop it. Listen.
You've been here all day, remember?
I know, right? So have I. On the revolving door that has been my office today. Middle. If A leases to B a tumble-down house, he is not liable in the absence of fraud to B's guests who enter injured. This is because B is then under the duty to repair it. The lessor has the right to suppose that he will fulfill that duty, and if he omits to do so, his guests must look to the lessee. Okay? On the other hand, if A leases a building to be used by the lessee at once, immediately, as a place of public entertainment, the rule is different. Their injury to persons other than the lessee, the persons outside the privity of the lessor-lessee contract, are to be affected, are to be foreseen, and foresight of the consequences involves the creation of a duty. Not in the contract that is the lessor-lessee relationship, but in the law that is premises liability. Don't forget that. That has a tendency to pop up in foreseeable places. And to Ms. Meyer's point, next paragraph, subtle distinctions are drawn by the defendant between things inherently dangerous and things imminently dangerous. The case does not turn upon these verbal niceties. If danger was to be expected as reasonably certain, there was a duty of vigilance, and this whether you call the danger inherent or imminent.
So defective is imminent.
Mm-hmm.
A defective product isn't imminently dangerous product.
And it's saying that it doesn't really matter if it's imminent or inherent. If there is a possibility that a third party is going to use it and be harmed by the defect, then there is a duty. Okay. I've got notes 1, 2, and 3 circled on 431. In note 1, it is clear today, however, that an individual who undertakes to make a repair owes a duty to use care to those who may be foreseeably injured in case the repair is negligently made. We are going to talk at the end of this chapter, I believe. Have we talked about non-delegable duties yet? Okay, so this is coming. Let's go back to our brake repair guy person. So what note 1 is telling us is that the majority, like, I have a duty to make sure that my brakes work. Okay, I have a non-delegable duty. All right. So let's say there's just some duties you can't give to somebody else. That's what non-delegable means. So let's say I take my brakes to the repair guy. The repair guy does a bad job. In Nonfeasance, fails to repair my brakes properly. Brakes fail. I run into Miss Dudley at the light out here. Okay. Miss Dudley is going to sue who? Me. Right? Is she going to win? Yes. Because it does not. Now, she's going to sue me. Is she going to sue him? No. I'm going to sue him. Right? My duty to her is to have my brakes working properly. His duty to me was to fix the brakes properly. Okay? I can't go to Miss Dudley. I can't say, well, this is the brake guy's fault. The judge is going to say, yeah, it might be, but it's your fault that you didn't make sure that he did it right to begin with. That's what a non-delegable duty is. Okay? Notice, note 2, liability for physical injury arising out of a failure to repair returns on whether the contractor gave an undertaking. And there it is again. If the repairer had done nothing at all, the case might have been deemed one of nonfeasance and the privity limitation might have applied. Right? That's back, Mr. Green, that's what I was talking to Mr. Green about earlier. Right? First sentence, note 3, if defendant commences performance and then omits to complete performance, he has committed misfeasance just as he had performed negligently and will likely be liable in tort, not in contract.
I don't like that. If you take it to the mechanic and he doesn't nothing, then he doesn't have any duty.
No, he has a duty, but he hasn't performed under the contract. Therefore, it's a breach of the contract. It's not a duty in tort. He hasn't assumed the duty by once he starts working on it. He has a duty to do it correctly. A reasonably prudent business person would not breach the contract. Okay, his failure to fix the brakes is he just hasn't done anything, right? The presumption is that if he fails to do the thing right, that's the proximate cause of the injuries, right? You're assuming that if he doesn't do anything, then, again, if he doesn't do anything, you're still going to have the same wreck. Might not be the proximate cause. Yes?
How is this different from the previous case? Where it said that if I have a tire in my car, I'm responsible for picking them up. And if I recognize that they're going down, fix them, they're just suing me. And if it's been betrayed or something, I can sue them. But for those who are speaking, we would put this as like the social law and say, I'm missing.
I'm not understanding your question.
Like why you said that felony would sue you?
That's right. I can't blame somebody else for my response. I can't make my responsibility of keeping my brakes up to snuff is my own.
But why can't she also sue you?
I'm not talking about a manufacturer. I'm talking about a repairman. That's different. The manufacturer, in the instance of the manufacturer, that's Product Liability Act, and she does owe it. And that duty, like I don't have a duty to manufacture my own car. Right? I have a duty to make sure that once I have that car, those tires are up. Those tires are well taken care of. Right? If it's on, if the tires are defective when I got it, right? Then she can sue Buick. It goes all the way up the hill, all the way up the line, Product Liability.
So the difference is a defect versus
Yes. Right. I don't have a duty to. I don't have, like. If the tires defects aren't, if I couldn't see that something was wrong with the tires, then I don't have a duty with regard to the tires. If the tires are worn and I can see the metal in the tires, then it's on me to get new tires. Yes.
This might be silly, I don't know, but like say you take your car to have like the belt placed something that's not too clear, not too obvious, and they say they do it, but they didn't. Is that misfeasance?
That's nonfeasance. If they don't do anything, it's nonfeasance. They breached their contract to you.
So they lied to you.
And then, that's right, and there you might have an action in deceit. Okay? That's back on page. Another is that a defendant, at the top of 425, another is that a defendant who makes a contract without the intention to perform is regarded as committing a form of misrepresentation or fraud for which a tort action of deceit will lie. Notice. What? No, that's a tort. Right? Notice there, what's the key word in that sentence? No. Hank? That?
I lost my space.
You're at the top. I'm at the top of 425.
Sorry.
Okay, but what is the key word in that sentence, Heather? No. Back up further. Intention, right? If he makes the contract without the intention of ever doing anything, then it's fraud. If he actually intends to do it, but say then lies about having gotten it done, let's say, okay, but here's the difference. Hey man, I'm dropping my car off to you. I need you to fix these belts. We'll use belts. I need you to fix these belts by Thursday afternoon, 3 o'clock. I need the car. I'm going out of town Friday morning. Okay? The intention at the time that the repairman receives the car is to actually fix the belt. However, something happens. Kid gets sick, whatever excuse, or he gets backed up. There's another emergency for a more, business-worthy, more regular customer, whatever, right? A more expensive repair, more profitable repair, and then he doesn't do it, right? You come to pick up the car, and instead of saying, I never got around to it, you can't have the car, thinking maybe I'll get to it next time you bring it in, he says, you're fine, go ahead. That's nonfeasance as opposed to fraud, because the intent was initially to do the repair. All right, that's enough of a rabbit hole. I'm going to go buy my rabbit. Start throwing it down the hall. Good job. Those are good questions, though. No kidding. So, HR mock. I did post some, if y'all haven't noticed, I did post some cases for you from the notes today on the Twin site, so you can take a look at them. But, so, we're back to the left side. Who we got? How about you, Miss Johnson?
Sure. So the plaintiff, whose mom, owned a warehouse that caught on fire, and he claimed that the defendant was responsible for the damages to the warehouse because they didn't supply enough water to the fire hydrant to put out the fire.
And who's our defendant?
Is the water.
Water company.
Yes.
Water
Who
company.
had the contract with the city. he didn't have a contract with the plaintiff.
That's right.
Okay, so procedural-wise, the plaintiff sued for breach as a third-party beneficiary between the defendant and the city. The defendant filed a motion to dismiss that was denied, but reversed by the appeals court, and then the defendant appealed that. For the issue, I just have, was the plaintiff an intended third-party beneficiary of the contract between the defendant and the city?
Good.
Did the city owe him, or did the defendant owe him a duty of care regarding water supply? And that the decision was affirmed. And the reason is because, no, there was no, what I gathered in terms of the rule was that for a third party to be a beneficiary, it has to be specifically stated that they are a third party beneficiary between A.
Right. There is no privity between, specifically, so the water company is a public utility that contracts with the city. So there's privity between the city and the contractor, but in this instance, even though the public is to benefit from the public utility, they owe no specific duty to the plaintiff in this instance because he's not an express third-party beneficiary, okay, of the contract. Very good.
A question, a part of that, in this case. It says that they knew about it and they still didn't do anything about it.
Where are you? Show me.
So it says the defendant, according to the plaintiff, was promptly notified of the fire, but omitted and neglected after such notice to supply or furnish sufficient or adequate quantities of water. First paragraph.
Right. Okay. The point here is that even though they did that, it might appear to be a breach. It might have been a breach of the duty to the city, but it's not a breach. They don't have a duty specifically to the plaintiff, and so therefore they didn't breach a duty by not doing that, even though they did. That's the point, right?
So they put that in there for what reason?
Put that where?
So they put that in.
Who's they?
Well, the people that wrote this up. They added this piece of information.
Judge Cardozo put that in there,
right.
So you better be careful.
Why did he add that there? If it was like no relevance to the third party.
No, it is relevant for the very reason that you asked the question. Like he's saying, yeah, they didn't do that here. The point is that even though they didn't do it, they didn't owe a duty, so it doesn't matter that they didn't do it. Okay? They didn't owe it.
Had something to do with maybe a decision they would have went against. Like, well, they were told, so they did, owe a duty based on knowing. Look
further down, Aretha. By reason of the failure of the defendant, quote, to fulfill the provisions of the contract between it and the city of Rensselaer, right? The plaintiff is said to have suffered damages for which judgment is demanded. Okay? The basis of the suit here is the breach of the contract between the water company and the city, not the breach of the duty owed by the water company to the plaintiff. Okay? So they're hinging on that breach, right? It's sort of a derivative sort of suit kind of thing. That's why it's in there. Okay, does that make sense?
Yeah. So the plaintiff could have sued the city instead of the water company?
Potentially. Potentially, yes.
If they could have proved that they intentionally didn't supply the water, could he have sued them directly? Like if they intentionally on purpose diverted the water elsewhere or something?
Well, remember now, we're trying to sue them in tort based on another contract, right?
But could you just throw that out and go directly?
If they had intentionally not done it?
Yeah. If you could prove that.
I mean, how would they, if you could prove that, how would that change?
Like say there was a different fire in another part of town, a more affluent part of town, and it's obvious that they diverted the water flow there to put the fire out there, so then your building.
Now we're getting into equal protection and all that stuff. That's beyond what. If they intentionally. I'll have to think about that. Let me think about it. Make a note, somebody. Remind me to think about that. That'll be number 86 on the to-do list.
Would you tell me what a dividend court is?
A what?
A dividend court?
Where's that?
It's in here. I wrote it down as a question. Don't ask me where it is.
I
It
don't.
was reversed by a dividend court. There's a motion to dismiss the complaint, which was denied. This was reversed by a dividend court. I just don't know what a dividend court was.
No, by a divided court. Divided court. Vicky.
I wrote it down wrong. That sounded like a good name for a court, so I just thought that
The
was...
dividend court.
Sorry.
That's all right. I thought it was a good question. I'm like, wow, I've been around a while. I don't know what that is either. Look halfway, 2/3 of the way down the large paragraph on 433. Everyone making a promise having the quality of a contract will be under a duty to the promisee by virtue of that promise, but under another duty, apart from contract, to an indefinite number of potential beneficiaries when performance has begun. The assumption of one relation, the one relation between the water company and the city, okay, would mean the involuntary assumption of a series of new relations inescapably hooked together. The law does not spread its protection so far. And again, notice that he says that, and he specifically uses the law and not the contract. The law, it's not the law contract. We have put the duty in the law, as he said in McPherson. I did, in note 2 on 433 there, I did pull Hall v. Consolidated Edison Court liability where plaintiff fell in the darkened hallway after defendant cut off power without notice. What makes that case different from this one? Or from the other one? Oh, I'm sorry, not from this one. Not the proposed case, but the New York City blackout of 77. What? In note 2, Hall v. Consolidated Edison Court. All right, we're told in the Strauss v. Bell Realty in the blackout case there was no liability, and in Hall v. Consolidated Edison there was. What's the difference?
This is
Because it
foreseeable.
wasn't reasonable pursuit.
No. Well, I mean, you can say foreseeable. Right, that's what you're getting at. I see what you're getting at. Say it, Arlana. Intent, purposeful. In Hall, they purposefully cut the power. All right, and I pulled it and I put it on twin for you. When the blackout was an accident. All right, was unforeseeable or was at least unpreventable. The summer of 77 was the summer of Sam, right? Summer of the son of Sam, blah blah blah, right? And that was an incredibly hot summer, and some of those murders revolved around the blackout. If you watch that movie about that, David Berkowitz. Dating myself again. Sorry.
I've seen it. I'm dating too.
I'll look it up.
Stokes. If defective water is in fact supplied, at note 4, if defective water is in fact supplied under a contract with the city, the defendant may be liable to an individual for resulting injury, such as typhoid fever. What's the point? Whew. What's Claggett v. Dacey about? Attorney liability. Ms. Cockrell, you want to brief this one for me?
Sure. Plaintiffs who were buying property at foreclosure sale,
they won the bid, but then later it was determined the foreclosure sale was improperly held at the hands of the attorney for the bank or the mortgagee. And so the foreclosure sale was determined invalid and the plaintiffs lost the property. And they filed suit because they had planned to sell the property for money. So they filed suit for breach of contract against the attorney who was attorney for the bank. And, or maybe not breach of contract, maybe breach of contract, see your face. But
No, you're right. I'm just, when you say that, I'm like, where did they think? I mean, I can't even believe they tried this. But go ahead.
Okay, so anyway, the court determined that that there is no duty owed. The plaintiffs were saying that the attorney owed them a duty, and that the attorney was not working for the plaintiffs, he was working for the bank. So they determined that the third party, the plaintiffs would be a third party, and the attorneys did not owe a duty to the third party. Therefore, they weren't negligent with respect to that third party.
And the court noted the sort of illogical position that the attorneys might be working for both the seller, or the buyer, and the seller and the buyers at the same time. Right? And every time I read this, I'm like, what do they think? Okay. So again, we're talking about, so in what situation are we told in the notes, Ms. Cockerell, when does liability under the attorney-client contract generally arise to a third party? Anybody catch that? There you go. When third party is the beneficiary, generally in the drafting of a will, right? The beneficiaries of a will, if a will is negligently drafted, then an action, there is a third party beneficiary aspect of that, and that's where this would come up most likely arise. Okay? There are a few passages in this case I want to point out. First full paragraph, 435. The Coppage Court made clear that only those persons who qualify under the normal rules for determining third-party biddings will be afforded the privileged status vis-a-vis attorney defendants, i.e. creditor beneficiaries. This would seem to limit extension to actions based upon contract to which the third-party beneficiary theory is peculiarly applicable and would not supply a basis for permitting third parties to sue attorneys on a pure negligence theory. Violation of some general duty arising in the absence of an underlying contractual attorney-client relationship. A duty arising in the law and outside of a contract, outside of privity of contract. Okay? And then it gives some more examples. At the bottom of the page, it becomes clear, when judged against these principles, it becomes clear that the declaration at issue here has failed to state a cause of action. It does not sufficiently allege a proper standing on the part of appellants to sue the appellee attorneys, nor from what is alleged could it do so. Appellees were engaged to represent the mortgagee, not the bidders, whose interest would likely be in conflict with that of the mortgagee. Okay? And obviously the bidders are outside the contractual relationship with the mortgagee, right? Are we catching how this contract versus tort theory is counterbalanced here? Is sort of put up, weighed against one another? Are we all catching that? BJ, you good? Cruz, you good? There are some minority cases listed in Note 3. Note 4 is what I was looking for. Cases in which attorneys have been held liable to third parties generally have involved beneficiaries of wills. But whenever an attorney's work product is primarily for the benefit of a third party, potential liability can arise. That's what we want to take from there. All right. Failure to act. Which side was that last one? Commonwealth. Rosa. Show me something.
This case is about the shooting.
Mm-hmm.
And
we got a lot of facts here. Try to summarize them a little bit.
All right. And basically, the action was brought by the two students who got killed by the shooter. It was brought by their parents, and it was against the administrator for the school.
Louder, Rosa, louder. I'm gonna bring the mic over there to you.
It was for the officials for the Virginia Tech School, and basically they alleged that the officials were negligent because they had a duty to warn the students of the danger that was posed by the shooter. And quick summary of the facts is that early that morning, like 7:30, the police got dispatched for a shooting on one part of the campus where it was one person died, one person survived. And they thought it was an isolated incident, so they were just working the investigation like it was normal. And then the officials got together, they tried to figure out what to do. But before that happened, really, another shooting happened about 9 on campus, and it was the shooter. Later, it was determined that
this was when our two decedents died, the second shooting, right?
exactly
Okay.
the people in the lawsuit, they got killed in the second shooting, and like the next day or whenever, it was determined that the bullets matched the same shooter. So the shooter that killed this person killed the other person. Okay. And then, so basically they're trying to decide whether there's a duty to warn of any unknown of a third party's criminal act.
Go ahead.
If a special relationship exists.
Right.
And then, so basically it was like, did the officials have a special relationship to the students to where they would have to?
Under these circumstances, right? I mean, these are pretty narrow circumstances.
Right.
And, okay, keep going.
Okay, and then, so the special circumstances, for example, could be like a common carrier or a passenger or like an innkeeper, a guest, or etc. And so, we talk about the arguments. Those are what this is.
Keep going. I'll tell you when I want you to stop. I'm not shy.
Defendants were arguing that the circuit court erred in finding that they had a special relationship to the victim and that they imposed the duty.
Okay, let's go back for a second.
Okay.
So under certain circumstances, we are told that the state of the Commonwealth of Virginia, okay, under certain circumstances, they have said that under certain circumstances involving a special relationship, I got it. Thank you, Rosa. Involving a special relationship, a duty has arisen to warn of what? Foreseeable criminal acts of third parties. Okay? We have an active shooter on here. There were 2 blast emails. This is where it gets a little fact specific, right, Rosa? There were 2 blast emails. One was sent after the first shooting to all the students saying there's a shooter on campus, right? Stay inside, right? Don't go out. And then, remind me, Rosa, there's another blast email. What was the second one about?
The second one was saying that the shooter on campus.
What was the first?
The first one was telling them that it was shooting that took place.
And they thought, but they didn't think it was an active shooting. Okay, I'm sorry. That's right.
Like be aware or something.
That's right. And the second one was about an active shooter.
Right.
What you left out was the officials at the university were told by no fewer than 3 police departments that they had arrived at the conclusion after the first shooting that it was a domestic incident, an isolated domestic incident.
Right, they thought it was
Right?
geared towards those.
And as they were interviewing the boyfriend of the first girl who died, they realized that the other one happened, right? So, so we've got two arguments put forth by the Commonwealth on 439, right, at the bottom. One, that the Circuit Court erred in finding that the Commonwealth and their employees had a special relationship, and two, even if they did have a special relationship under these circumstances, they had no duty. Okay? Notice at the top, as a general I'm on 440, folks. At the very top, as a general rule, a person does not have a duty to warn or protect another from the criminal acts of a third person. This is particularly so when the third person commits acts of assaultive criminal behavior because such acts cannot reasonably be foreseen. Okay?
Couldn't they even argue that when they put the bolo out that they kind of did warn when they were looking?
Where's that?
What I'm saying is, when they did put the bolo out looking for the boyfriend, couldn't the state argue that they were?
Well, wait a minute. The bolo.
Bolo's for law enforcement.
Yeah, bolo's just for law enforcement,
But
not for the.
They were still putting it out to law enforcement to be on the lookout.
Yeah, but that's not warning. That's outside of the special relationship between the school and the student.
I think it
You see what I
also
mean?
said on that first blast email something about they thought he had left the area or something.
That's right. Right, because that was on the. But wait a minute, we're missing the point here. The bolo is between the cops and the university. That's between the cops. The special relationship, what we're talking about, is the special relationship between the university and the students.
Right.
So the bolo didn't go to the students, is what I'm telling you.
So even with the bolo, the university didn't have a duty, right?
University would have got it.
I don't understand what we're talking about. I'm really confused.
I'm trying to figure it out.
We got a bolo is between law enforcement agencies.
Yeah, in that first email, they told the students to look out for
Yeah,
suspicious
look out for
behavior.
Yeah.
So that could have been kind of like
Oh, I see. Okay. Once the female's boyfriend was identified as a person of interest, a bolo went out for him. Yeah, that's a bolo is between cops. They don't email the students and go, "Y'all be out on the lookout for."
They did.
What?
Yeah, they sent a flash message.
They said it wasn't the first message just said to be on, just be looking for suspicious behavior or something. I can't remember exactly, but it did say something about.
Because there was two messages.
Hang on a second.
438.
Where is the first blast email? Where is it?
438.
Start on the bottom of 438, the last two sentences on that page.
Yeah. The alert for anything suspicious at the top of 439.
It's the
Third paragraph. The second full paragraph. It's the last line of 438.
Okay, so at 9:26, we had one blast email that said a shooting had occurred in Amlo-Johnston Hall, and then 19 minutes later, we had 24 minutes later, we had a second blast email at 9:50 saying that there was an active shooter on campus. None of which indicates that the bolo went out to the student.
Well, I guess that's
Okay. All right. So that issue is now resolved. What is the next one? What have I missed now? All right. There are two in the middle of 440. We have recognized, second sentence in the paragraph beginning, a review of our prior cases. We have recognized two levels of foreseeable harm: known or reasonably foreseeable harm, and imminent probability of harm, the heightened degree of foreseeability that arises where the defendant, quote, knows that criminal assaults against persons are occurring or are about to occur on the premises based upon notice of a specific danger just prior to the assault. Bomb scare. Okay? Next paragraph. In instances, however, where the special relationship was that of business owner, invitee, or landlord-tenant, we have imposed a duty to warn only where there was, quote, an imminent probability of injury from a third-party criminal act. Thus, the duty to warn of danger from third-party criminal acts has remained an exception to the general rule. Okay? That's right. No, not going there. Notice what it takes to impose the duty in the middle of 441. Tabo auta, or however you would say that. Over a 3-year period immediately prior to the attack, hotel employees had called police 96 times to report criminal conduct, including robberies, malicious wounding, shootings, and other criminally assaultive acts. 96 times. Right? I'm not going there.
Free continental breakfast.
Not even for the free continental breakfast. So the reason that the court reverses the trial court here is because under the circumstances, right, it was reasonable for the Virginia Tech administration, because on the basis of 3 reports from 3 separate law enforcement agencies, that the initial incident was an isolated domestic incident, and that they had no reason to believe that there remained an imminent danger on campus. That's why they kicked it. Okay?
But schools do in general do have a way to keep their students safe, right? We don't.
But in another case, they say,
I'm sorry, what now? Wait a minute. That's a good question. Say that again, Ms. McNeil.
I said, but schools, they do have a rule, they have to keep their students safe, right?
Right, but only if it's foreseeable that there's danger, right? Like, you know, it's foreseeable that a transient might want to try to come in the front door. That's why Cash and Finley are downstairs, right? And what are you saying, Ms. Colbert?
No, I mean, I just said that, like, we don't have that. I mean, there's no
Who's
rule.
we?
Like, I teach, and, I mean, we don't have, unless we're alerted of, like, an intruder in the building, there's no...
Are you saying we as a teacher, or we as the administration of your school?
Teacher. We as a teacher.
Yeah, you as a teacher, but she's asking about the school. The school system absolutely has a duty to protect. And you know, and this is all in flux, right? This is all in flux. What about it, Mr. Dixon?
I guess maybe I missed it. You probably explained it earlier. But when they were the mix up about the bolo and the email blast.
Are we back to that? Come
I want to make sure that when you talk about breach of duty, when they initially found the first 2 on campus and assumed that it was just isolated event, did not have a duty of care to send an email out saying that they did at 9 something. As soon as that particular incident happened, when they found the 2 bodies.
They did send an email about. They didn't send it as soon as possible. As soon as it happened around 8, right? They discovered the bodies around 8. you know.
What happened is that they had a glitch in their computer system, and so it was supposed to go out, but it was delayed.
Ah, okay.
It was an issue with the system.
Yeah, they had a couple things go wrong, but ended it out.
I still think we're hung up on.
Either way it went out.
Either way, it went out
Right.
at 9:26.
Right.
It wasn't perceived.
So what? I mean, what's your question?
No, I was. that's
When
what I
when
meant.
the when
I thought
when?
they did not send it initially when they found the first two.
Oh well, yeah. No, they tried to send it. Apparently, they tried to send it, and there was a glitch. But nevertheless, they didn't say everybody stay indoors at that point, because the Blacksburg Police Department and the Virginia Tech Police Department and probably the state troopers had all said, at this point it looks like it's over, whatever, okay? If they had said something different, right, then we have a different set of facts and we have a different set of circumstances, and it might, right? If it appeared at that point that it wasn't an isolated incident and the cops had said that to the administration and then the administration hadn't sent the email telling everybody to hide, now we got a different set of circumstances, right? It's under, remember, as I said, as Rosa was talking about it, this is a pretty narrow holding, okay, with regard to this particular set of circumstances. But to Ms. McNeil's point, I mean, yes, I have a duty to make to take reasonable precautions, right? To act as a reasonable night school, weekend school, to make sure that you guys, that the students are safe, and thus that's why Cash and Finley are downstairs. Okay. I'm not saying it. I'm not. I'll call it myself. Yes.
What happens if there's an emergency downstairs? Is there like an alarm here or something?
There's a window.
Yeah, we've got a speaker system and all sorts of things. You can pull a fire alarm. Don't use the elevator.
Where are we now?
What's the and what is it? Run, hide, fight. Right.
Have you seen the videos? They're wonderful.
All right, Hagel v. Langsam. This is one of my. This is a jewel right here. I sent my teenage daughter to you people, and she is hanging out with ne'er-do-wells. She's staying out all night, smoking that Mary Jane, and it's your fault.
You didn't walk her in her room.
I'm gonna.
How dare you not watch her?
That's right.
You're supposed to be babysitting her.
What? I mean, just read it. University to become associated with criminals, to be seduced, to become a drug user, and further allowed her to be absent from her dormitory and failed to return her to her parents' custody on demand. You bring her to me. What? All right. So there is no duty, obviously. I mean, and God bless the Court of Common Pleas of Ohio here, Judge Bettman. A university is an institution for the advancement of knowledge and learning. It is neither a nursery school, a boarding school, nor a prison. No duty to regulate the private lives of their students, to control their comings and goings, and to supervise their associations. This is in 1971. There was some tie-dye involved here. All right.
Wow.
I did pull in note 2. I pulled Davidson v. University of North Carolina, Chapel Hill, where the university owed a duty of care to a cheerleader who sustained injuries during practice. And I'm assuming, I pulled it, but I didn't read it. It's out there for you. I'm assuming that the duty of care is to help her once she is injured, because there is an assumption of the risk for athletic activity. Right? Right, well, they have a duty to make sure that the rest of the team isn't drunk, maybe, yeah.
Is that the same thing like with the football player?
Yeah.
The football player that at Maryland?
Or
Any football player, what do you mean?
like if they get injured while they're playing?
Yeah, you have a duty to, well, I mean, the Maryland football player, right, that died at practice, dehydrated, right, he died in spring training, he was dehydrated and died. Now, obviously, that is a breach of duty. Like, it is that coach's job to take care of those athletes, right, to make sure that they're hydrated or whatever. Now, if it's an unforeseeable, congenital heart condition that has been undetected, that goes back to that it's unforeseeable, right? Yeah, student athletes pass away. I mean, what was his name? Hank
Gathers.
Say it again? Gathers. Hank Gathers, right? Hank Gathers at Long Beach State back in the 80s. Just dropped. Hank was 19 years old and was, an All-American.
It was during a game, I think.
Yeah, it was during a game. He dropped dead. I think it might have been during a game. He just dropped dead right in the middle of the game, or at least right in the middle of practice of a heart attack. Okay, but the duty that arises is once the injury happens, because there is an assumption of the risk. I mean, football players know that playing football is dangerous, right?
So if they had known that he had issues with his heart, but still let him play because.
I mean, think about who's the other. Who recently in the last couple of years she's talking about, if they know he has a problem, who is it? And they go ahead and let him play. Who's not being allowed to play? Chris Bosh. That's right. He's got blood clots. Chris Bosh has blood clots, and he is an all-world basketball player. And the Heat said, "Look, man, we're not putting you out there." Even though you want him, and Chris was upset. Chris wanted to play, and the doctors wouldn't clear him. And the Heat said, "You're not going out there. We're not going to let you play." Okay, for fear that Chris's estate would sue them where he'd die on the court.
Yeah, but if he's under release, I mean, wouldn't that free from any liability?
No.
Still not a risk they're willing to take.
That's not a risk they're willing to take. I wouldn't let him do it. No, sir.
That's a medical night.
Right.
Basketball.
The basketball.
Sorry.
Different sports this time of the year.
Circle note 3 on 443. Read that, some of those sections from the third restatement there. So in heirs, boy, 6-year-old, right? Is it 6-year-old?
Yes.
6-year-old gets his hand stuck in the escalator, and an employee of the store, or the department store, delayed stopping the escalator. And because of that, the child's injuries were aggravated, So what's the issue? Does a business owner have a duty? Does a duty arise in a business owner to an invitee who is injured on the premises to act to either eliminate or mitigate the injury? And the answer to that question obviously is yes. And the difference here is what? What's the difference the court tries to make in the big paragraph in the middle of 444? Like, was it the negligence of the store owner that caused the injury to the child? No, it was if any negligence, it was on behalf of the manufacturer of the escalator. So, does the store owner have a duty to mitigate the damages caused by the negligence of a third party? And the answer is yes, right? In the middle of that big paragraph. Thus, it has been said that, under some circumstances, moral and humanitarian considerations may require one to render assistance to another who has been injured, even though the injury was not due to negligence on his part and may have been caused by the negligence of the injured person. Failure to render assistance in such a situation may constitute actionable negligence if the injury is aggravated through lack of due care. There is your holding and issue all in one fell swoop. Okay?
So this is different from like the rescue.
The what?
The rescuer rule that
Yeah, this is different because the rest. Right, this is different.
Because you said we could just walk by and not even try to help them.
That's right. You're not under any duty to help anybody. Right. The duty arises here because it's an invitee. That's right. And the other thing to remember is, once you undertake the help, right, even in the rescuer situation, you got to follow through, and you can't do it negligently, right?
By driving 8 miles per hour.
Right. Last paragraph on 444. In some jurisdictions, the doctrine has been extended much further than we are required to do in deciding this case. It has been held to apply to cases where one party has been so injured as to render him helpless by an instrumentality under the control of another, even though no relation of master and servant or carrier and passenger existed at the time. It has been said that the mere happening of an accident of this kind creates a relation which gives rise to a legal duty to render such aid to the injured party as may be reasonably necessary to save his life or to prevent a serious aggravation of his injuries, and that his subsequent duty does not depend on the negligence of the one party or the freedom of the other party from contributory negligence, but that it exists irrespective of any legal responsibility for the original injury. Okay, that seems to militate against what you were saying, right? But that's the minority rule. The court is saying that other courts in certain instances have extended this way beyond further than what we're trying to do here. The majority rule remains the same. You might feel a moral responsibility to help me if I'm drowning, but you're not under any legal duty to do it. Not that you would anyway.
Yeah, it depends on who it is.
Penultimate paragraph. In the case at the bar, the appellee was an invitee and he received his initial injury in using the instrumentality provided by the appellant and under its control. Under the rules stated above and on the authority of the cases cited, this was a sufficient relationship to impose a duty upon the appellant. Notice, since the duty with which we are presently concerned arose after the appellee's initial injury occurred, the appellant cannot be charged with its anticipation or prevention. In other words, there was no negligence in the operation of the escalator initially, but only with the failure to exercise reasonable care to avoid aggravation. In other words, you should have moved faster to stop it after it happened.
That goes back to the rest of the thing, because you have a relationship, you got a rescue. It happens a lot.
I'm sorry?
I mean, if you have a relationship.
Speak up so everybody can hear what you're saying.
If you have a relationship, you have to rescue them.
Well, yeah. Well, like what kind of relationship?
Even in the last one, like in the last semester, we learned something about, there was an exception to that rule, that you didn't have to rescue.
Right, a parent-child, yes.
So here there was a relationship, so they could rescue.
There was a relationship created by his status as an invitee.
Yes.
Yes. There it is at the bottom, toward the bottom of note 1, after the Murphy v. Morgan citation. Thus, quote, once the state assumes custody of a person, it owes him a rudimentary duty of safekeeping no matter how perilous his circumstances when he was free. The distinction tracks tort law. There is no duty to rescue, but having effected it, the rescuer is not entitled to harm the person whom he has rescued. Yes.
Remember the case where the elevator was inoperable and a service person's thumb got hurt? Is this different because maybe it was cut off? Anyway, is this different because no one was rescuing that guy?
What case were you talking about?
It's a case where there's an elevator malfunction and they could have been to a contract. Anyway, an elevator malfunctioned and there was the service people there to repair the elevator, but they forgot to tell people to shut it off. And so some employee of the company got on the elevator and his thumb got cut off.
I remember that case, but I don't think that was our case. It wasn't in here. It was a contracts case. I remember that case, but I don't think we've read it in here.
I was curious if it was different because of the rescuing.
Well, what was the outcome?
I don't remember. I think the outcome was that there was I don't remember. Maybe it was contracts.
It's because they were.
Well, hunt it down and shoot me an email. Now we're just speculating. She doesn't know what it is.
It was negligence per se because there was a statute on it. There was a statute on it saying that.
All right. Before I can answer the question, I got to read the case. Somebody send me the case and I'll answer it. You're fine. I remember that case, but I don't think
there was a rule that they had to barricade the elevator before they worked on it.
I remember the case. I don't remember the outcome. I'd have to look at it.
We did say.
So JS and MS versus RTH. What we have here is what? Who's our defendant? The wife of a sexual abuser, right? And the question is whether a person who knows or should know, right, that abuse is likely to be taking place given the totality of the circumstances, okay, whether the duty to prevent or at least to warn others of the probability that abuse is taking place. Can we impose that on a spouse? And the answer to the question is yes. Here we have a situation where the husband was spending an inordinate amount of time with two young girls, alone with two young girls, and the wife never so much as confronted him about it, apparently never so much as confronted him about it. And so the court, despite having some reservations about public policy, says yes, we can impose the duty here, and we should. Top 47, in determining whether a duty is to be imposed. Remember, this whole chapter is about when we impose the duty and when we don't. Courts must engage in a rather complex analysis that weighs and balances several related factors, including the nature of the underlying risk of harm, that is, its foreseeability and severity, the opportunity and ability to exercise care to prevent the harm, the comparative interests of and the relationships between or among the parties, and ultimately, based on considerations of public policy and fairness, the societal interest in the proposed solution. That's a nice tight little list. If you didn't highlight it, do it now. Third sentence, third paragraph. Such knowledge may also be constructive. The defendant may be charged with knowledge if he or she is in a position to discover the risk of harm. Further down, last sentence of the paragraph beginning, the question whether there is a duty merely begs the more fundamental question whether the plaintiff's interests are entitled to legal protection against the defendant's conduct. Last sentence there, also implicated in this analysis is an assessment of the defendant's responsibility for conditions creating the risk of harm and an analysis of whether the defendant had sufficient control, opportunity, and ability to avoid the risk. First full paragraph, next page, 448. In the final analysis, last sentence, in the final analysis, the reasonableness of action that constitutes such a duty is an essentially objective determination to be made on the basis of the material facts of each case. And then the court walks through why should we impose a duty on a spouse here? Because they're in the best position to see what might be going on. They also are charged with, understanding that with certain, demographic data, right, that most, the implication by the court is that, people should know that most child abusers are men, most child abusers are even married men, right? And so certain suspicious behavior should give what? Constructive notice to the spouse that something may be amiss. I mean, at this, can't we all agree that under these circumstances she should have at least confronted him about it? Okay? Huh? Right. I mean, you know. Well, I mean, that's another matter, right? Wait a minute. Yeah, 12 and 15, two young girls, 12 and 15. Substantial periods of recreational time in the barn. Anyway, yes?
Just a quick question. What does it mean here where it says the court granted defendant's petition for certification?
Oh, that's petition for certification, that's a writ of certiorari, right?
Oh,
Right, so we're in the Supreme Court of New Jersey, right? So without noticing whether so we went at the top of 447, we went from summary judgment on behalf of the defendant and went through the appellate division reverse. And so at that point, the defendant petitioned the Supreme Court of New Jersey for certification of the question that is presented here. And that question is whether a duty should be imposed on it. It's called to the Supreme Court at the very least, it's called a writ of certiorari, the certification of the question. And you petition, you're asking the court to address it. And there, if I remember the number correctly, there are like 2,000 petitions for writs of certiorari issued every year to the Supreme Court of the United States, and they only take like 20. Okay, maybe a few.
Spousal immunity still in effect?
For the most part, it's gone the way of the dodo. We're going to get to that chapter. Check it out. We've got a bright line rule. I mean, the court really lays down the law here. I mean, no pun intended. At the top of 451. I'm glad Bird enjoyed that. Accordingly, we hold that when a spouse has actual knowledge or special reason to know that the likelihood of his or her spouse engaging in sexually abusive behavior against a particular person or persons, a spouse has a duty of care to take reasonable steps to prevent or warn of the harm. Further, we hold that a breach of such a duty constitutes a proximate cause of the resultant injury, the sexual abuse of the victim. Can't be much more clear than that. The failure to warn, if you're in a position to know, constitutes proximate cause. So you can't argue otherwise, right? Good stuff. I've got note 1 circled. I did pull Connolly v. Nicolette Hotel for you, where a convention in the defendant's hotel got out of hand and started menacing everybody and everything in the vicinity, and the management was held to be under a duty to make reasonable efforts to control it. That was a heck of a party. I've got note 2 circled. Okay. Terrace-off. Y'all, when Terrace-off comes up a lot. Okay, Terrace-off is about the duty of a psychiatrist to warn the target of threats of unbalanced individuals that are revealed in the psychologist and the doctor-patient relationship. The thing to remember, the answer to the question is there a duty if there is a specific threat against a specific person? The answer is yes. Okay, in this instance, this deranged individual told his psychiatrist that he was compelled and was going to kill the victim. Okay? The thing to remember here is that it's got to be a threat that's specific to a person or a small group of people. Okay? It can't be that the duty does not arise, okay, if it's a threat to society in general or a group or a large group, right? You know, you know. Yes.
Are they supposed to tell the police and then let the police warn the victim, or are they supposed to call the victim directly?
I mean, that's going to be sort of one of those issues that's going to be resolved jurisdiction by jurisdiction.
Okay.
In certain instances, it may be sufficient to call the police and say, "Hey, look, I think this is going to happen," and leave it to the police to warn. I mean, in this instance, he did tell the police, right? And then the police held the guy,
right, and
then let him go. I mean, it's hard, and police officers, who are my police officers? It's hard to hold folks if you don't. I mean, how hard is it? I mean, you might not know the answer to this, but I mean, if somebody calls the precinct or a doctor says, "Hey, this guy's a real threat. You need to go pick him up and let him cool off or whatever," I mean, you got to have a real particularized reason to keep him for more than 48 hours, right? I'm not talking about arrested here. I mean, what does it say? He called police. Potter was an outpatient under the care of a psychologist at Cowell Memorial. During the course of treatment, Dr. Moore learned from Potter that he intended to kill Tarasoff because she had spurned Potter's romantic advances. Police detained Potter apparently at the hospital. I mean, shortly after, it doesn't even say. Signed by whom? A circuit judge, okay. Yes, ma'am.
I can show you specifically for the city of Birmingham and Jefferson County. You can bring in a person to the hospital under the statute 353, and they will be held for up to a week.
Up to a week.
Yes, the order is signed by a probate judge.
But you've got to go to the judge to get the order.
Right. You go to the
Who goes to the judge to get the order?
Whoever is filing the petition.
A family member can? Can the psychiatrist go?
Anybody in the state of at least in the state of Alabama, anybody can go to court.
Wait a minute. What's the burden of proof here? What do you have to allege, and how much do you have to show?
You have to allege that they are a danger to themselves or others. And that can be as simple as they have made threats that they're going to kill themselves.
Or specific threats that they're going to kill Dean Garrett?
Right, or if they're making threats against somebody else, and you can take them involuntarily to the hospital and they will be committed and they will see a probate judge within 7 days and be evaluated during that 7 days by a psychiatrist.
So you get pissed at your spouse.
And I know our psychiatrists at UAB, if a patient comes in and makes specific threats, they make every effort to contact the person directly. They don't just call.
They don't call the cops. They
will if they cannot get the contact information for the specific individual, but they make every effort to contact the specific individual to let them know.
But see, that's great information. But see, that takes it out of the psychiatrist-patient relationship, right? Part of the issue that the court has here is one of the dissenting judges in the former edition of the book. There's a dissenting opinion, and the fear is what? That if there is a danger that, why do we have the psychologist-patient relationship? Yeah. Because they've got to be the patient is supposed to be comfortable in revealing everything to the psychiatrist in order for the diagnosis or whatever, the treatment to be effective, right? And so the dissenting judge, and one of the dissenting judges in this case, says, wait a minute now, if we impose this duty on the psychologist and the psychiatrist to report these threats, then it's going to have a chilling effect on the effectiveness of therapy in general, because even people with violent fantasies or violent inclinations are not going to be truthful with and open with their psychologist. So that's a legitimate fear, right? Okay, or a legitimate concern, I should say. I think, though, in the final analysis, and so what the court does here is obviously they balance that versus, what right, how much of a right does the target of one of these violent fantasies have, to know that somebody is out to get them, right? And what, and for them to have knowledge to take reasonable precautions to protect against the attack. Yes?
If you could be held for 7 days before you see a probate judge and held before you see a psychiatrist, let's say somebody just with a bad attitude lied about a situation. What is your recourse if you're held against your will until you see a psychiatrist?
That's a common law question. This is Torts class. I mean, there is one tort action, and we'll talk about it later this term, called misuse of the legal process. But that's if you prosecute somebody falsely, right? Here, I mean, that's why I asked Mr. Stravinsky, like, what exactly do you have to say to the probate judge to,
Yeah, but I mean, if you're held for 7 days, you can see a probate judge.
Well, right, okay. Again, there goes that rabbit, right? Right? That's why I asked the question. Like, I don't know what you have to say to a probate judge to get somebody committed for 7 days as a danger to themselves or somebody else. Right? I don't know the answer to that question. Apparently the bar is pretty low.
It is.
Which is unsettling. I agree with you.
Dean Garrett?
Yes?
In this case, there doesn't need to be an actual action. There just has to be a threat.
Right. This person, I mean, let's just imagine, I mean, just for the sake of argument, let's say that this guy meant it. Like, you could look in this guy, that whatever his name is, like, he looked in this guy's face and he said, I want to kill this Tarasov girl, and he believed it. Right? This was not a fantasy. This is, I'm gonna do it. Right? Okay? So, yes. I mean, to the point that he called the police, right? So the answer to that question, so I don't think, notice at the top of 454, obviously, second sentence, first full, obviously we do not require that the therapist in making that determination render a perfect performance. The therapist need only exercise, quote, that reasonable degree of skill, knowledge, and care ordinarily possessed and exercised by members of that professional specialty under similar circumstances. They only have to act as a reasonably prudent person would under the same or similar circumstances. Y'all didn't notice that, shame on me. Okay? In our view, here's your holding, 2 paragraphs down. In the paragraph beginning, amicus contends. What is amicus? Y'all remind me? Friend of the court, right? In our view, however, once a therapist does in fact determine or under applicable professional standards reasonably should have determined that a patient poses a serious danger of violence to others, he bears a duty to exercise reasonable care to protect the foreseeable victim of that danger.
So instead of just calling the cops and telling the cops, he should also notify the terrorist officer.
Yes, I think that's the case, right? I think that, well, whatever reasonable, depending on the duty to exercise reasonable care, it depends on whether the reasonable care is calling the cops or calling her directly, right?
Doesn't that open him up? Doesn't that open him up to lawsuits if?
That's the problem, right? That's what the dissenting opinion. That's the problem, right? Because the therapist has to gauge whether it's a violation of the confidentiality agreement,
Right. I mean,
versus
right. But damned if you do, damned if you don't.
Yeah. Well, I think that the court is giving them a lot of leeway here. There's like if it's reasonable for you to warn them, then you need to warn them. And that's the countervailing public policy, right? It's more important. The confidentiality provision is less important than the right of the person to know that somebody's about to try to kill them. That's the ultimate determination. Yes.
I was just thinking that in some states, I think that DHS, I don't even know what it's called here, DHS and adult services becomes sort of like an
Intermediary.
between the courts and the providers to keep the confidentiality while also proceeding.
Well, I mean, in this instance, I mean, we're talking about, I don't think we know enough here. Yeah, I'm not going there. Just because, I mean, for instance, if DHS never gets involved, if it's 17-year-old Mountain Brook kid, with a drug problem, daddy's paying for the therapy, DHS never gets involved. That's a direct relationship between the 17-year-old and, Dr. Snodgrass down at Grandview, right? When we start talking about DHS or DHR or whatever, generally, in many instances, the state never sees it. I've got note 1 covered, circled on 455. Note 2, describe the duty that should be imposed on a physician who finds that her patient is HIV positive. Note 4, is there a dangerous patient exception to the psychotherapist patient privilege? Note 5, and goes back to what I was talking about the general threat. In the principal case, the duty was owed to identified victim. I'm going to kill Tatiana Tarasov, right? When the threat is not pointed but general, the authorities are split. A juvenile in Thompson, a juvenile offender was released into his mother's custody despite his history of violence and known desire to kill a young child if he were set free. He accomplished this within 24 hours of his release when he killed the plaintiff's son. The court reasoned that no duty of care obtained because the generalized threat here in juxtaposition to the direct threat in the principal case would have been an ineffective guard against violence and might have adversely impacted the patient's rehabilitation. The other issue here is how are we going to impose a duty? Like I want to go kill, telling, I don't, obviously. But, the statement, I want to kill a teenager, you know, how are you gonna issue that warning, right? All teenagers be on guard. I've got 6 and 7 circled as well. I mean, just look at 7. The court found no duty to warn when a psychiatrist had failed to alert a patient's parents that the patient had suicidal propensities and was running risks by consorting with heroin addicts. Okay, so imagine that cause of action, right? Kid, you know, teenager, on heroin, commits suicide. It's not an OD. It's an intentional act of suicide. Okay, and so the parents have been sending the child to a psychiatrist, Dr. Snodgrass. Okay. Expecting Dr. Snodgrass to fix the child, right? And so, and of course they're grief-stricken, and so they say to themselves, they say to the doctor, like, why didn't you tell us? And what are they going to base that question on? The fact that they were paying the bill, right? They're going to say, we were paying you to fix this problem. You should have told us that our child was on the verge of killing herself. And you also should have told us, right, that she was going out with a bunch of smackheads. Okay? On whose side of that argument are you? The parents? Wait a minute now. This goes back to what we were just talking about with the danger of the psychotherapist privilege, right? If the child is aware that it is likely that the doctor will tell the parents about the drug use and who she's hanging out with, how likely is it that she's ever going to tell them about the drug use and the heroin and all? She's never going to say it, ever. And that is definitely going to that is going to prevent the doctor from doing his or her job effectively. Right? So be careful when you start talking. I mean, obviously y'all are parents and y'all would be grief-stricken and indignant too, right? But just be careful about what you're thinking about there, right? And it doesn't say here, I mean, what we're not told. But all we have here is suicidal propensities, right? Do you think about suicide? Yes. How often do you think about suicide? Well, you know, sometimes I get really depressed, right? Those are suicidal propensities. That's not the direct statement, I am going to kill myself the next time I get high with my friends. All right? All right. I'm tired. Y'all are tired. It's 5:45. It's going to rain. Hey, listen, y'all. I mean, we're going to have to get through all this, so, and we're going to do it effectively. I don't want y'all getting to the end going, man, we never learned about misuse of legal process. We kept going home early. You were always hungry. Pure economic loss. Hey, listen, and let me, before we all bug out, pure economic loss is pretty easy, okay? And then we're stopping on 457. Emotional distress is pretty easy too. Okay, we're all familiar with that. Emotional distress. That's negligent infliction of emotional distress. And then we get into what are the vague areas of right to live, right to birth, etc., and that we won't spend a whole lot of time on unborn children and Procanic and those cases. So now we're on to 495 or around 500, and that's it. And then we skipped 9. We've already done chapter 9. That's why we're skipping it. And we're going into damages. How long is the damages chapter?
See you in 2 weeks. You gonna be here? Vegas, baby.
Let's just go ahead and say we're going to get into damages next week, okay? All right, fair enough?
What case do we start?
Just start on 457, pure economic loss. Okay?
We almost saw an assault at Pizza Hut. And then the guy claimed he had Tourette's at the end. 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 Tourette's at the end.